Hi friends, good morning. So today's discussion is about a topic which almost all governments across the world are keen about. So the gig economy or the sharing economy as they call it, like your Airbnbs and Ubers of the world. The governments across the world have had concerns in about how we go about taxing these people. If you look at people who work in, let's say, a website like freelancer.com, where clients from different parts of the world work with service providers from different parts of the world. What extent of these monies are being declared for taxation by various countries? And as the size of this economy only keeps getting larger and larger, the governments throughout the world are now finding it increasingly important to figure out rules to bring these incomes to taxation. So OECD on its part, just as how we saw the CBCR guidelines, which came into picture and which is also being implemented by different countries in different forms, has also made significant efforts in this direction. And this is one of the first building blocks of the rules in this regard. So what we are going to now see is the OECD's model guidelines or rules for reporting on sharing and gig economies. I would sincerely thank Anand and Jugal for their efforts. A fairly complicated topic and a heavy reading. So this is how the whole pan of things work out. The entire rules are split up into four parts. One is on definition and relevance, due diligence procedure, reporting requirements, administrative enforcement, and of course the public consultation areas. CBCR country by country reporting, OECD 10 is for tax identification number. Let's look at the overview of this regulation, of these rules to start with. So, gig economy it refers to digital platforms that allow independent freelancers to connect with individuals or businesses for short-term services or asset sharing. And classic example could be asset sharing services like Airbnb, transportation services like Uber, professional services like Urban Clap or freelancer.com, handmade goods, household and miscellaneous services like care.com. We're only talking about the shared economy. So the market for this platform uh, promotes sharing, and gig economies is growing rapidly globally, and therefore this is also leading to significant increase in transparency and minimize compliance burdens for both and can minimize compliance burden for both tax administration and taxpayers since the entire transactions are online. However, certain activities performed through these platforms may not be visible to the tax administrators or reported by taxpayers. The reason behind is a shift from traditional work relations under employment contracts, where you have a compulsory withholding, to provision of services by individuals on an independent basis, which is typically not subject to third party reporting. It's in this background that OECD is taking this step at the policy level on the development of model reporting rules for operators in sharing and gig economy in its public consultation document. The rules mentioned in the public consultation document could be adopted on a uniform basis to collect information on transactions and income realized by platform sellers. So, what is a policy framework? First, building blocks for the overall framework. Then you have model rules and commentary to collect information from the resident platform operators. Framework for the automatic exchange of the information between jurisdiction. Development of technical solutions to support exchange of information and performance of due diligence. So the public consultation document contains a current draft of the building blocks. Once the model rules and commentary has been completed, the second and third building block will further be developed in due course. The public consultation again it seeks comments before the 20th of March 2020. What are the objectives of the model rules? Okay, so the intent is to get timely access to high quality information about taxpayers to tax administrators, promote standardization of reporting rules, promote international cooperation between tax administrations, provide a reporting regime that can also be used for other tax related purposes, promote the development of new technical solutions to support the performance of due diligence, ensure that the scope of model rules remain adequate, efficient, and targeted. Definitions and relevance. So, software, when we look at certain definitions, first let's start out with software. Platform. Platform refers to software including a website or a part thereof, and applications accessible by users and allowing sellers to be connected thereto. You can visualize Airbnb. It also includes services associated to relevant services, including the collection of consideration. So, a platform solely to offer its own services and without the ability for third party sellers to provide relevant services for the benefit of other users would not be considered a platform. Classic example is any e-com service provider, let's say a Carrot Lane, which is entirely into selling gold jewelry, which it manufactures. Anything of a marketplace would fall within the ambit of platform. Again, seller platform uses that a platform user who is registered at any moment during the reportable period. It can include both individuals and entities. Again, when we say registered, it needs to be interpreted broadly to include instances where a user has created a profile on the platform as well as entered into a contractual obligation. Excluded sellers, entity for which the platform operator facilitated more than 2,000 relevant service transactions service transactions for the rental of immovable property in respect of a property listing during the reportable period, a government entity or its related entity, the stock of which is regularly traded. So if it's a public enterprise. So if you look at the first case, it's interesting. Entity for which the platform operator facilitated more than 2,000 relevant services transactions for the rental of immovable property in respect of a property listing during the reportable period. Coming back, what do you mean by the term relevant services? Because we have seen that affecting various other parts of the regulation. So, relevant services, short term and long term rental of immovable property or personal service for consideration. Immovable property again includes residential as well as commercial. A personal service as a service involving time or task work performed for the benefit of a user, unless such work is ancillary to the transaction or requires significant infrastructure supported by staff. Personal services usually fall into one of the two categories: services that can be carried out online and is thus capable of being delivered to other users worldwide. Services that, while facilitated via a platform, are physically carried out offline, usually at a physical location. So you're talking about classic case of freelancer or an Uber being covered here, or Airbnb. And to ensure that the rules remain future proof in light of rapid advancement, relevant services shall also include any other service as determined in secondary legislation of the jurisdiction. So, a reporting platform operator should first determine whether a transaction is for the sale of goods or provision of service, and whether, if it's for service, whether it comes under the ambit of relevant service. Again, if a transaction involves elements of both relevant services and components that are not subject to reporting, and both elements can be split or identified by the reporting platform operator, the operator may report only in respect of relevant service component. Where the elements cannot be split, the entire transaction should be subject to reporting unless it is proved that service is ancillary to the non-reportable component. Now, platform operator, again, an entity with the sellers to make available all or part of a platform to such sellers. Such contract will generally provide the seller with access to the platform for the purpose of offering relevant services to other users. Consideration, compensation in any form which is known or reasonably knowable by the platform operator. Consideration paid to any third party account specified by the seller. Amount net of any fees, commission, or taxes withheld or charged by the reporting platform, if paid in any form other than fiat currency. Again, fiat currency is physical currency paid without any intrinsic value that has been established as money, often by government regulation. And any of these forms, the consultation should be reported in the local currency of the jurisdiction in a manner that is consistently determined by the reporting platform operator. Reportable jurisdiction. Again, the relevant scope of report for the reportable sellers subject to the reporting are required to report in their jurisdiction of tax residence. So the reporting platform operators are required to report this in the jurisdiction of tax residents and report in respect of reportable sellers resident in reportable jurisdictions. Jurisdiction implementing the rules will be interested in receiving information in respect of the sellers resident in their jurisdiction. Include any jurisdiction with whom information collected under model rules can be exchanged in respect of a particular reportable period. So, and again, when we say reportable period, it is the calendar year, and the reporting should take place before January 31st of the subsequent year. So, what we are now seeing is a concerted effort. If let's say Airbnb is a classic case, Airbnb has to declare for each jurisdiction the number of people who had their tax residence in that jurisdiction. Any seller other than excluded seller that provided relevant services during the reportable period and is either tax resident in a reportable jurisdiction or provided relevant services for the rental of an immovable property located in an reportable jurisdiction shall be deemed as a reportable seller. Partner jurisdiction. Any jurisdiction which is identified in a published list as partner jurisdiction, and published list would reflect jurisdictions that have adopted substantially similar reporting rules and that have an arrangement in place to exchange reportable seller information. The list would avoid duplicative reporting in case there are multiple platform operators for the same platform. A reporting platform operator may designate another platform operator to comply with the reporting obligations in respect of all or a category of sellers to the extent the platform operator is resident in the same jurisdiction or in a partner jurisdiction. So the above propositions are similar to bilateral arrangements uh, between countries for exchange of CBCR information. Property listing. All immovable property units located in the same street address and offered for rent on a platform by the seller can include a hotel room or any other form. In this light, multiple hotel rooms rented by a seller as part of a hotel with the same street address shall be treated as single property. Similarly, separate apartment units rented in a building with single street address by the same seller are also treated as single property listing. Few more definitions before we get into the operational part of the local service provider is a relevant service by its nature, which requires the presence of the seller, which needs to be performed in a particular place, and it is sufficient if that performance of the relevant service is linked to a specific jurisdiction. Similarly, reporting platform operator is a platform operator that is a resident for tax purposes, and that does not have a residence for. If he does not have a residence for tax purposes, he is either incorporated under the laws of the jurisdiction or as a place of management in the jurisdiction. It does not include an excluded platform operator, which means that who is incorporated less than 3 years before the beginning of the reportable period with a revenue of less than 100,000 euros. It excludes startups from the scope of model rules. So again, institutions which are in the early stages. Entity again is a legal person. Tax identification number, a unique number issued by the tax jurisdiction. Primary address is the registered office address of the platform operator. So if you look at the model rules, friends, the rules talk about determining whether the seller is providing relevant services and comes within the ambit of a reporting seller or an excluded seller. Collection of information what by the reportable platform for a non-excluded seller. Verification of collected information using reliable independent source, determination of jurisdiction of tax residents, reporting of information to the appropriate tax authorities, and if information collected is no longer accurate, collection of new information. Literally, they are asking the platform owners to do the due diligence of the KYC of the sellers on the platform. What is the DD procedure? So sellers are not subject to review. For the purpose of determining whether an entity seller is an excluded seller, a reporting platform operator may rely on publicly available information. A platform operator is not required to carry on DD procedures to the extent that another platform operator is carrying out the DD and reporting obligations pursuant to these rules, or substantially similar rules in a partner jurisdiction that has included each jurisdiction of tax residents of such sellers in its reportable jurisdiction. So if you've done it in one place, you don't need to repeat it. Collection of seller details, we're talking about collecting KYC details of the seller. The operator is not required to collect the above information in case it's relied on a government verification service. Like in India, we have this eKYC verification. The reporting platform operator must collect the following information for each seller that is an entity. Again, the basic KYC, including the tax identification number. Verification of seller information. The verification should be done using reliable independent source documents, data, or information. For individual sellers, this may include national ID cards or driving licenses. For entity sellers, a legal name can be verified, for example, using an incorporation or resident certificate. The reporting platform operator may rely on the name provided by a seller, where procedures are in place to verify that the name provided by the seller corresponds with the name associated with the bank account on which the seller receives consideration. Determination of jurisdiction of tax residents. So the primary determination in each jurisdiction confirmed by a government verification service, the reporting platform operator must consider a seller a tax resident in each jurisdiction positively affirmed by a seller and confirmed based on current certificate of tax residence. So TRC is required. Secondary determination, the jurisdiction of the seller's primary address, and if it is different in each jurisdiction of issuance of tax identification number. Similarly, in each jurisdiction in which the seller provided substantially all local services that are not purely incidental in nature during a 183-day period. So very important because the onus is now on the platform operator to comply with these rules. Collection of rented immovable property details, uh, where a seller provides relevant services for rental of immovable property, the reporting platform operator must collect the address of each property listing and land registration number wherever issued. Um, where, based on the information available, a reporting platform is not aware of the precise address of the property, it should put procedures in place to reliably collect the address. Very, very onerous the requirements. Timing of the DD procedures. So a reporting platform must ensure that the information and documentation collected on each seller is available by 31st of December of every calendar year. The confirmation can include obtaining seller's explicit statement that previously collected information are still valid and does not require any change. And all the procedures shall be completed by 31st of Jan of the following year of the reportable period. Very, very clear guidelines, standard of knowledge, where a reporting platform has reason to know that the information or documentation is not or no longer accurate, it must ensure to collect new information or documentation prior to 31st of December. Now, report are the reporting requirements of the reporting platform. Um, Prior to within 31st of Jan, subsequent calendar year in which the consideration is paid, um, the reporting platform should give details about the consideration paid or credited to the reportable seller for the relevant service uh, in the respective XML schema which has been provided for. And the provision seeks to ensure that the reportable sellers are aware of the information provided on their behalf to the tax administration and that it may be used for filing their annual tax return. The information to be reported, KYC details about sources of income, total consideration paid, any fees or taxes withheld with respect to each reportable seller that provided immovable property rental services. The following additional information are required to be reported: address and land registration, number of each property listing determined on the basis of procedure, number of days each property listing was rented during the reportable period and the type of each property listing. Data transfer requirements. With respect to each seller for which a platform operator has designed another platform operator, it must transfer any information the platform operator holds on the seller and that is relevant and not already available to the designated platform again by 31st of December. A platform operator that ceases to perform the obligation of another platform operator with respect to a seller must transfer or make available any information it holds and that is relevant for and not already available to the other platform operator again before the end of the reportable time frame. Administration and enforcement. This is where the tax officers are interested. The section provides implementing jurisdictions guidance on how the rules are to be effectively implemented. The hallmark of effective implementation set out here could take the form of primary or secondary legislation supplemented by guidance, reporting operators, platform operators to close or freeze accounts of sellers that do not provide required information. They should keep records of the steps undertaken and the information relied upon for diligence procedure, administrative procedures to verify reporting platform operators' compliance, administrative procedures to follow up with the reporting platform operator where incomplete or inaccurate information is reported, effective enforcement provisions to address non-compliance. Where a platform operator does not maintain any physical presence in the jurisdiction, it may be challenging for the jurisdiction to enforce model rules against such a platform operator. One enforcement option could be introduction of joint and several liability of the platform operators in respect of reportable sellers' personal income tax obligation, combined with the rule stating that such liability may be removed where a platform operator complies with the model rules. And good compliance outcomes at the level of sellers could be achieved by providing sellers with a tax incentive. Draconian suggestions, but still, yes. Option to change definitions in model rules. Although the primary mechanism based on residence of the platform operator remains with the preferred approach under the rules, jurisdictions adopting the model rules may consider creating a secondary mechanism that ensures local reporting in the jurisdiction in which the sellers are resident or where immovable property being rented is located. So two changes to the model rules are required to achieve this outcome. One, the definition of the reporting platform could be altered, or definition of a reportable jurisdiction can also be altered in this regard. What are the questions the OECD is interested? Comments on scope of platform operators and delegation mechanism, excluded platform operators, relevant services, excluded sellers, DD procedures, reporting requirements, secondary mechanism. Code of conduct. It sets out the core element of cooperation between tax administration and platform operators, standardization of soft law approaches to the provisions of information, and prompts by platforms can reduce burdens on individual tax administration. Code of conduct can make sellers understand their obligation, assist them in reporting taxable income, and facilitates the sharing of information with tax authorities. The code of conduct only concerns actions which are not already required by law. So the draft code of conduct for platform operators, I think this is more what I would say. It's more procedural in nature, but they've given the responsibility for platform operators vis-a-vis sellers, vis-a-vis tax administration, and their general code of conduct. So these were some of the thoughts, friends, on this burning conversation regarding how platform operators are going to be regulated in future, with the fact that most of them now operating in a jurisdictionless manner, and the fact that they now have to report every jurisdiction to every jurisdiction on the uh, list of sellers with their incomes and tax details. I think we are in for some really interesting times as the world is now coming together to tax the gig economy. Let's wait and watch in terms of how these rules eventually fructify. Thank you for your time and hope to catch up with you on another conversation of relevance during the week. Thank you.